Supreme Court blocks Louisiana abortion law. The New York Times. Washington. The Supreme Court on Thursday that its opponents say could have left the state with only one doctor in a single clinic authorized to provide abortions. The vote was 5-4, with Chief Justice John G. Roberts Jr. joining the court's four-member liberal wing to form a majority. That coalition, the court's brief order gave no reasons, and its action a temporary stay did not end the case. The court is likely. Justices Clarence Thomas, Samuel A. Alito Jr., Neil M. Gorsuch and Brett M. Kavanaugh said they would have denied the stay. Only for Chief Justice Roberts, it was something of a turnaround, at least for now. He dissented in the abortion rights advocates welcomed the court's order, which came around 9:30 p.m., only hours before the law was to go into effect. The Supreme Court has stepped in under the wire to protect the rights of Louisiana women, Nancy Northup, the president of the Center for Reproductive Rights, said in a statement. The three clinics left. Chief Justice Roberts' overall voting record has been conservative, and this was not the first time in recent months he has disappointed some of his usual allies. In December, that same month, he from three conservative colleagues for voting to deny review in two cases on efforts to stop payments to Planned Parenthood. But Chief Justice Roberts has voted to sustain other laws restricting abortion. And his vote to grant the court is likely to confront other abortion cases, too, as several state legislatures have recently enacted laws that seem calculated to try to force the Supreme Court to consider overruling Roe v. Wade. The Louisiana law, enacted in 2014, requires doctors performing abortions to have admitting privileges at nearby hospitals. In 2007, the law, Judge de Gravels ruled, was essentially identical to one from Texas that the Supreme Court. Justice Breyer, there was no evidence that the Texas law's admitting privileges requirement would have helped even one woman obtain better treatment, Justice Breyer wrote. But there was good evidence. The vote in the 2016 decision was 5-3, with Justice Kennedy in the majority. The case was decided. Justice Kavanaugh replaced Justice Kennedy last fall, shifting the Supreme Court to the right. Around the same time, unlike Texas, Louisiana presents some evidence of a minimal benefit, wrote for the majority. In particular, he added that the Louisiana law does not impose a substantial burden on a large fraction of women. Judge Smith, in dissent, wrote that the majority's ruling was impossible to reconcile with the Supreme Court's 2016 decision in the Texas case and with its landmark 1992 ruling which banned states from placing an undue burden on the constitutional right to abortion. I fail to see, Judge Higginbotham wrote, how a statute with no medical benefit that is likely to restrict access to abortion can be considered anything but undue. The full Fifth Circuit by a 9-6 vote. In dissent, I am unconvinced that any justice of the Supreme Court who decided whole woman's health would endorse our opinion, Judge Higginson wrote. The majority would. The clinic and doctors challenging the law filed in the Supreme Court asking it to block the law while they pursued an appeal. Louisiana is poised to deny women their constitutional right to access safe and legal abortion with an admitting privileges requirement that every judge in the proceedings below the district court, the panel majority and the dissenters agrees is medically unnecessary, the challengers wrote in their application in the case, No. 18A774. One doctor at one clinic cannot possibly meet the needs of approximately 10,000 women who seek abortion services in Louisiana each year, they wrote. Some of these women, lawyers for the state that the law would be administered in a cautious way, with no immediate changes. The challengers, saying that doctors without admitting privileges would risk immediate civil, criminal, and professional liability if they performed abortions after the law became effective. Given the number and severity of the law's penalties, no clinic or doctor without admitting privileges will continue to provide abortions once the law becomes enforceable, they wrote. Irreparable harm. In his dissent on Thursday, Justice Kavanaugh said he would have provisionally denied the stay to let the factual questions be sorted out. Notably, the Fifth Circuit, he wrote, had predicted that the 4 doctors who provide abortions at 3 clinics could obtain admitting privileges. There was no dispute. If those doctors can obtain privileges, Justice Kavanaugh wrote, the new law would not impose an undue burden under the Texas decision. By contrast, if the 3 doctors cannot obtain admitting privileges, Justice Kavanaugh wrote, then 1 or 2 of the 3 clinics would not be able to continue providing abortions. If so, then, the right solution, he wrote, would have been to deny the stay and let the challengers return to court if the doctors could not obtain privileges.
Raindrop, drop top smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up, open the park pot.